Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's nicest indoor shooting facility. That, of course, being Security Gun Club right here in beautiful Woodinville, Washington. Listen, I'm going to talk to you about a story that's been kicking around in the YouTuberverse and other social media platforms for the last few days. It has to do with a Vermont man who apparently is now sitting in prison until his personal range is destroyed. Now, there's been a lot of people speculating, a lot of people doing some conjecture, a lot of people a little exaggerating as to what occurred here, but there is a real story here and there is some real concerns here. So today, let's kind of separate some of the exaggeration from the facts. Let's get you all up to speed and let's get you educated on the Vermont man who will be held in state prison until his range is destroyed. Okay, so the issue we're talking about today is a Vermont resident, Daniel Banyai. He is from Paulet, Vermont. I don't know anything about Paulet, Vermont. I candidly don't know much about the state of Vermont at all. It's one of the few states I have not been to, except to say that the town folk of Paulet, Vermont, the city council and their state representative, well, they're rotten to the core. You see, in a rare instance, one that is rarely if ever seen, Mr. Banyai was served by the Vermont Court of Environment with a writ of minimus. Now, you sit there and you go, what the hell is a writ of minimus? I will tell you that when I heard it, I too said, what the hell is a writ of minimus? I had to look it up. But what it essentially is an order to be held in custody until you comply with the court's order. Now, to suggest and to oversimplify the problem that Mr. Banyai is being held in jail until his range is destroyed on his own personal property is a little bit of a misnomer. All of that is true, but you see what Mr. Banyai is being held in jail for is contempt of court. And yes, unfortunately, in almost every state in the country, can a person be jailed for contempt of court? Yes, they can. Now, all of these allegations have to do with a range, which he calls Slate Ridge, that he set up on his 30 acres of land that he purchased approximately 10 years ago. Now, of course, the neighbors started complaining about the noise, and that led them to go to the city council and ask for all sorts of zoning restrictions. Now, I want to point out that what all the neighbors were complaining about was the noise. There is no allegation of any person being endangered, that rounds were flying onto neighbors' property, that they were being endangered, that they were being caught in crossfire, anything like that whatsoever. So the sole complaint here was one of noise. Now, I'm not saying they don't have a complaint, but I want to make sure that we understand the parameters of what we're dealing with. Now, when the zoning commission couldn't screw Mr. Banyai enough, what did they do? Well, they then filed suit in the Vermont Court of the Environment. Now, I don't even know what the Vermont Environmental Court is. I'm shocked that any state actually has an environmental court, and I shudder to think what this court actually does. But they sued in that court to have the range removed from Mr. Banyai's property. So essentially what we have is a bunch of concerned citizens coming together and filing a lawsuit to tell a property owner what he can and cannot do with his own property. Now, there was also additional allegations that Mr. Banyai had constructed several structures on the property. I don't know whether they're related to the range or to some other of the agricultural activities that occurs on the farmland, but apparently those buildings allegedly were built without the proper permitting. Now, in issuing the writ of minimus against Mr. Banyai, the court ruled respondent has demonstrated a willfulness, perhaps even an enthusiasm for disregarding the town's bylaws, this court's orders, and the authority of the judiciary. And of course, this deals in relation to when the environmental court issued an order for Mr. Banyai to strip his property of all of those structures, to absolutely tear down every aspect of the range, to move the earth back to its original condition. Well, Mr. Banyai chose not to comply with that order. So in issuing his writ of minimus, the judge responsible for this also was quoted as saying, "Respondent has failed to do so. As such, imprisonment is an appropriate coercive remedy in these circumstances." But is there more going on here? Because when you listen to Mr. Banyai's attorney, Mr. Robert Kaplan, there is much, much more to the story. And what's more nefarious about this is how these concerned citizens then got a state representative, a state senator involved, got legislation drafted exclusively to screw Mr. Banyai, but when you see this legislation, you'll see the dangers of what has passed here. Now, Mr. Kaplan, attorney for Mr. Banyai, is quoted as saying, "A lot of people in the community didn't like the fact that Daniel offered people a place to shoot and its dynamic facility, not just a flat range. Vermont has a lot of leftists. Guns scare them, and people moving around with guns really scares them. The people in the town formed a posse to drive a new guy out of town over zoning issues." And as I mentioned earlier, when the town of Paulette could not screw Mr. Banyai with their own zoning laws, what did they do? Well, they went to a state senator and had legislation drafted, which was ultimately then signed by a Republican governor. You see, Vermont State Senator Philip Baruth, at the bequest of the town of Paulette, actually drafted and got passed into legislation statutes which ban paramilitary training. And I know you sit there and go, what the hell is paramilitary training? I'm not really certain myself, but what Vermont and everyone else needs to be aware of is this is how that statute, now good law in Vermont, reads. A person shall not teach, train, or demonstrate to any person the use, application, or making of a firearm, explosive, or incendiary device capable of causing injury or death, or techniques capable of causing injury or death to persons, if the person knows or reasonably should know that the teaching, training, or demonstrating is intended to be used in or in furtherance of a civil disorder. But wait, there's more, because the law also makes it unlawful to assemble with one or more other persons for the purpose of practicing or being taught, trained, or instructed in the use, application, or making of a firearm, explosive, or incendiary device capable of causing injury or death, or in techniques capable of causing injury or death to persons, if the person knows or reasonably should know that the practicing, teaching, training, or instruction is intended to be used in or in furtherance of a civil disorder. Now, what defines in furtherance of a civil disorder, I'm not certain, but as you can see what the intent is, and this is what everybody needs to be aware of, is you're going to see more and more legislation passed like this, which is going to be intended to drive shooting ranges and practice and training facilities out of business. Well, this has unfortunately left Mr. Banyai with no other choice but to file a federal lawsuit against the town of Paulette, which he has done. He is alleging that their actions are in violation of both the Second Amendment, yes, and the 14th Amendment, yes. He's also requesting immediate injunctive relief as well as reward of all attorney fees. We will keep you posted. This is an interesting case. In the meantime, Mr. Banyai actually just awaits for someone to come pick him up. He has actually not been arrested yet. He is not in custody yet, and there is a possibility that this case may end up with some type of alternative resolution. But we do need to keep our eyes closely peeled on this one, because this goes to show what happens when a small group of people are hell-bent on civilian disarmament, because when they don't get their way with their own city council and their zoning laws, they will just go up the ladder further, and when they will finally get a state senator to pass legislation. But when that's not enough, then what do? Well, then they go to an environmental court and they sue. And I can assure you that had they been unsuccessful here, they would have continued to find and look for venues until someone ruled in their favor. Listen, if you have any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.